Welcome to the Parkinson's Foundation's Wellness Wednesday program, Financial and Estate Essentials for Life with Parkinson's. Thank you for joining us today. PD Health at Home is presented by the Light of Day Foundation, whose generosity has made today's programming possible. Today's program is part of our PD Health at Home virtual program series. Each week, we offer sessions tailored to support people with Parkinson's and their care partners, including Mindfulness Mondays, Wellness Wednesdays, Fitness Fridays, care partner programs, and expert briefings. We also have our Spanish language series, Salud en Casa. So be sure to visit our website to see what's coming up and explore our videos on YouTube. You can learn more about our upcoming virtual programs and register at parkinson.org/pdhealth. This Friday, we'll have our live Fitness Friday program with Dr. Meredith Roberts-Lowe from Parkinson's Point. Hope to see you there. Today, we're pleased to offer a program on financial and estate essentials for life with Parkinson's. Planning for the future can feel daunting, but it's one of the most meaningful ways to care about yourself, to care for yourself and your loved ones. Our speaker will break down the basics of financial and estate planning in clear, practical terms. Learn how to protect your assets, make informed choices, and create a plan that reflects your values and priorities. Whether you're just getting started or revisiting your plans, you'll walk away with the tools and the confidence to move forward with a peace of mind. Feel free to submit your questions at any time using the Q&A button on your screen, and we'll have time to answer questions towards the end. Again, this program is being recorded, and we'll share a copy of the slides and the webinar summary in a follow-up email. And with that, I'd like to introduce our presenter for today, Colleen Ceh Becvar. Colleen is a gerontologist and owner and co-founder of Oak Brook-based Trinity Advocacy Group, an advocacy firm that fights for the rights of vulnerable adults. Colleen's 30-plus career of unapologetically giving voice to the underdog began naturally in grammar school and created space for her to step into impactful roles such as being a delegate to the White House Conference on Aging, published researcher on elder abuse and neglect, and invited speaker both locally and nationally. Most recently, Colleen began her 2-year presidential term for the Aging Life Care Association. Colleen is an outspoken supporter of anti-ageist efforts and is motivated every day for every client by a very personal mission and very simple vision, a world without ageism. Colleen, thank you so much for joining us today and for sharing your expertise.
Thank you so much for having me. It is a delight to be back here at the Parkinson's Foundation. Thank you so many of you for tuning in today. We have already nearly 70 participants. I want to apologize in advance. I am getting over a cold, and so the laryngitis that I have, as I was joking with Danielle and Brianna before we hopped on the call, I feel like I am back in my college days where I was smoking, but I assure you I was not. But bear with me. If I need to take a sip of water, I will certainly do that. I'm very excited to be with you here today. My name is Colleen Ceh Becvar. And let me see, I'm going to be sure that there we go. Today we're going to learn, as Danielle just described to us, what estate planning is, what's involved in that. But this is from a non-attorney perspective. I want you to know the steps to take before beginning the process of financial and estate planning. It's not mainstream conversation, but it's really important. And as somebody who will serve as a power of attorney or an estate executor, and we'll get to all those words in a little bit, I have found over and over how difficult it is for most people who do not live this estate planning language and financial language day in and day out, but who are really facing an uncertain future, that making things simple, relatable, and walking away with some very practical tools is very helpful. So that's my goal for you today. And also, of course, addressing issues specific to Parkinson's. And so welcome, relax, enjoy. As you know, Danielle mentioned you will be getting a copy of these slides, and we are happy to answer your questions. So I'm going to take you through some a formal presentation. We will have time at the end for Q&A. Please go ahead and share your questions as you are able. So, as I mentioned, I'm not an attorney. I'm a gerontologist by background and by training. I always like to tell people that a gerontologist is not a geriatrician. So a geriatrician is to older adults what a pediatrician is to children. A gerontologist has studied aging from multiple perspectives, including biology, psychology, the economics and ethics of aging, and my work as an advocate for seniors and their families for over 30 years in my profession makes me a gerontologist. So a big part of what I do as a gerontologist and as an advocate is I create what's called a care plan. Now, I don't do that in a vacuum. Our clients are very important, and I would like you to imagine for yourself throughout this presentation that you and I are talking about your care plan. So, your care plan, from my perspective, we're going to look at that from multiple factors go into that. But there are no factors more important than the two that drive every single care plan. It does not matter where you live. It does not matter how much money you have. Two factors drive every care plan universally, and that is the care that you need and the resources to pay for that care or to manage that care. So not everybody can pay for private care, but you might have care support through family, through volunteers. We're going to get to all of those things. Let's start with this very important piece of the care plan puzzle, and that is estate plan. And I'm going to demystify this word called estate plan. What is it? You know, you hear this all the time, and a lot of times people think of estate plan and they imagine this beautiful, sprawling estate. And if you have that, hats off to you. Most of my clients don't. They don't have this beautiful mansion. This happens to be Walt Disney's mansion. But I don't want you to think about an estate as this sprawling piece of property, though that can be included in what we call an estate. Really, the real term, what an estate refers to, is all your stuff. It's your stuff. It's the computer you're watching from or the phone you're listening from. It's the shoes in your closet. It's the car that you drive or used to drive. Yes, it's the money in the bank. It's the toothbrush. It's the junk drawer that you have in your kitchen, like we all do. An estate simply means all your stuff, everything you own. And if you are fortunate enough to have real estate as well, like this beautiful estate, Walt Disney estate, that's also part of your estate. Why? Because it's property, it's stuff, it's tangible stuff. Okay. So keep that in mind as we move forward. Now, you all know what a plan is. A plan is putting things together so you know where you're going. That's all an estate plan is. Let's assume for the moment that you have that sprawling estate and you are the king or the queen of your castle, and you, through this thing called your estate plan, a plan for all your stuff and what you want to have happen to it, you, as the king or the queen of your estate, get to say what happens to all of your stuff. How do you do that? You declare that. You tell people, this is what I want. This is important to me. This is what I want for my health, and this is what I want for my finances. Now, very interestingly, there's really only 4 documents that are part of an estate plan. And guess what? 3 of them have to do with your stuff. 3 of them have to do with your money and all your stuff. Whether that's coveted stuff like jewelry or heirlooms or the toothpaste that we were talking about. There's really only one document that in an estate plan that references and that governs what you want to do with your health. And I've always found that as an advocate very interesting because while money is important to people, I find that my clients are much more concerned about giving voice to what will happen to them when it comes to their health. So, this power of attorney for healthcare document, in my experience, is far more personal and more important to clients. And so, I'm going to make that intuitive leap that that is most important to you as well. We're going to talk about all of these documents, but we're going to focus first on this care piece because, as I said, that's most important to my clients. So, you may already know this. And as Danielle pointed out at the very beginning of this presentation, those of us who are attending today's presentation, some of you, this is the first time you've had exposure to this language. Others of you are looking to reestablish your estate plan, to update your estate plan. So this might be review, but follow along either way, because in my experience, there might be some things in listening to this presentation, if you've had your estate plan for a long, long time, that gets you thinking about some changes or updates you might want to make. So forgive me if this is rudimentary for some of you. I do hope that it's useful to everybody. Just so you know, your power of attorney for healthcare, when you make a decision about who that is going to be, who's going to make decisions, it's very important that you know a couple of things. Number one, you should make your own care decisions as long as you are able. And even if you can't make some of those complex decisions down the line, you should give voice wherever you can to the decisions. If the more complex decisions are ones that you want to give that agent the authority to make, great. But along the way, that person should be should be asking you along the way. They're also going to look at the documents you work really hard to complete for guidance when the day comes that you are not making your own decisions. That's when this power of attorney for healthcare is crucially important. We all know that Parkinson's is a progressive disease. So I have not met a client yet who has Parkinson's where they haven't needed that agent to make decisions for them at some point. Maybe it's not permanently, but that they really want that person sort of taking over while they're recovering from a setback or an exacerbation of their Parkinson's symptoms. So when you give that authority to somebody else, you're asking them to make care decisions, to have surgery or not, to have that intervention, whether it's medicinal or medicational, whether that's a treatment option, whether it's food, clothing, shelter. Are you getting those basic needs met? Do you have access to medications? Do you need an advocate? Because that power of attorney for healthcare, that is their most important role as your agent under the power of attorney for healthcare, is to know and understand what your decisions are for yourself and give voice to those when you cannot give voice to those decisions. It is not the job of the power of attorney for healthcare to override the decisions you make for yourself. It is actually to carry the torch for you of what decisions you would make for yourself. That's a crucially important point that I want to make because it's not really up to the agent under the power of attorney to make decisions that they would make for themselves. They may not agree with the decisions that you want for yourself, but it is their job to follow the breadcrumbs that you leave for them in your power of attorney for healthcare. It is their job to make sure that they are following your decision making and implementing those. It's not to override your decisions, it's to implement them, whether they like them or not. So I always tell people It's very important when you're naming a decision maker for yourself that maybe it's not the child or the relative or the friend who lives closest in proximity. It's the person that can withstand the pressure of making sometimes very emotional decisions, but that really they're making those decisions that fully align, that they can withstand that, as I said, the emotional pressure and stay strong in face of the doctors that you want every intervention, if that's your decision, or you want no interventions, if that's your decision, and stand in strength. And although it may be difficult, to keep your voice top of mind at all times in making those advocacy decisions for you. The other thing that's really crucial with with an agent under the power of attorney is that they are there for crisis management to get you through those hospitalizations, to make those decisions, and that give you back the reins when you're ready, when that crisis has abated. And then, crucially important, are end of life decisions. You've got a lot of life to live, hopefully, God willing, between now and the time any of us meet our maker. So there's a lot of life to live before those end of life decisions come up. And I'm going to say I have more to say about end of life decisions towards the end of the presentation. Let's move on. I told you earlier that there are three documents that really address the financial or your stuff. So those three documents, we're going to talk about those individually for a moment, in a moment. But I want to tell you first what all three documents have in common. So I'm talking right now about the three documents. One is called your power of attorney for property. Again, property in a state, that just means your stuff. It means your real estate, yes. It also means your bank accounts. It means your car. It means the clothes you're wearing. It means your paper clips. It means your diamond rings. It's your stuff, okay? So your power of attorney for property is one document. Then there's your trust document. Not everybody has one. Not everybody needs one. That's a decision for you to make with an attorney. And then the last one is your last will and testament. What these three documents, beyond having your financials, right, all of your stuff in mind, including your finances, they all have similar responsibilities. Each one of these people in each one of these roles have the authority to negotiate agreements on your behalf. They have a responsibility to secure your property. Let's say you have a house and you have titled the name of the house into your trust. Your trustee has a responsibility to pay the bills, the electricity, the water, to make sure that your house, which is an asset, maintains its value. They all have the responsibility, they have the authority, rather, to move money around, not willy-nilly, but according to your documents, according to what your documents say. You might be saying to yourself, well, Colleen, how do I know what to do? How do I know where to tell them where to move those? You don't have to do that alone. You need to do that with an attorney, a financial advisor, and a CPA. If you have any of those, great. That's a great place to start. I'm going to tell you more about those options as well. They all have a responsibility to review and approve your expenses. Anybody who's writing a blank check on your behalf is not doing that on your behalf. They want to review those expenses and approve them before they're paid. They have the responsibility to sign contracts. You can limit that authority in your documents if you'd like to. There's ways that you can do that. They can hire people and fire people. Let's say that your doctor is simply not responding. In conjunction with your power of attorney for healthcare, they can, or that's a bad example. How about caregiver help? Let's say you have a caregiver who's providing services in home and they're just not showing up. In concert with your power of attorney for healthcare, you and your power of attorney for property, your trustee, they can fire that person. They cannot pay them. So that's very helpful. Opening your mail, that's a huge responsibility. Also, filing your taxes. You want to be on the right side with the IRS. And so, your power of attorney for property, your trustee, and your executor under your will, they all have to pay your taxes. And then, of course, they have to pay your bills. So, these are all the things that each one of these folks need to do. Now, there's parameters, there's limitations for each one of these roles, and there's responsibility for each one of these roles. Do you need all three of these documents? Usually not, but that is not for me to decide. And frankly, it is for you to decide, but not in a vacuum. You want to talk with an attorney, and I'll tell you why I'm so adamant about an attorney. Some people on this call are saying, sure, Colleen, easy for you to say. I don't have the money to hire an attorney. I'm going to address that. Let's move on. Now, a moment ago, I told you there are three primary documents. So I'm going to go back a slide. Do you see at the top of the slide, there's the power of attorney for property. And at the bottom of the slide, we've got a picture of your last will and testament. We're going to forget about this middle document called the trust for just a moment. The power, excuse me, the power of attorney for property and your last will and testament, they are related in a way. Importantly, your power of attorney for property only has the authority to pay your bills, open your mail, pay your taxes until the moment you pass away. Well, Colleen, what about my bills? What's going to happen after I die? If my power of attorney for property has been paying all my bills during my lifetime and everything stops, they can't pay anything more at the time I pass away, which is legally accurate. They cannot. They no longer have that authority. Who does that? Great question. That question is, or that answer is the person who picks up the baton when you pass away is the executor of your estate. So that authority that ends with your power of attorney for property, the moment you pass away, that's it. Every check that has been written, no more. They no longer have that authority. That baton, that responsibility passes immediately to the executor of your will. And I'll explain why in just a moment. So just to review, your power of attorney for property only has authority, and for health, by the way. Your power of attorney for healthcare and your power of attorney for property only have authority for you during your lifetime. Okay? That authority ends at the time of death. That baton passes, as I mentioned, after death only. Now, you will not need a power of attorney for healthcare after you pass away, right? So you were only really very worried about who keeps those bills paid, who keeps paying your landscaper, for example. Your executor of your will is going to do that. Now, I told you why these two are so important to each other. The power of attorney for property and the executor of your will, even though their authority ends, one ends when you die, one's authority only picks up when at the time of your death. They manage the assets that are in your name alone. What do you mean, Colleen? What do you mean assets in my name alone? I want you to imagine your bank statement. If you have a bank statement, you can picture that right now. And let's say your name is John Jones, and you can see on my slide, think about how your bank account is titled. Think about all the stuff in your house. Who owns it? Do you own it? Is it jointly owned by somebody else? For a lot of people, they might retitle their assets, which we're going to get to in just a second. but the power of attorney has a responsibility to manage only things in your name alone. If there is an asset that is titled jointly with a spouse, with a child, or that is retitled into the name of the trust, which I'm going to get to in a moment, that your power of attorney has no authority under any assets that are not in your name alone. Period. They cannot touch anything that is not in your name alone. Same thing with your executor. Your executor, in picking up the baton from your power of attorney for property, can manage only assets in your name alone. Period. Okay. So let's talk about this fun document. I think it's fun because it's the trust. It's the only document in your whole estate plan out of all four documents. This is the only one that bridges your lifetime and after you die. So during your lifetime, if you have put your bank accounts, some of your investments in the name of your trust, you've retitled them into the name of the trust. During your lifetime, typically, if you have bank accounts or your houses, then you've put the deed, you've renamed it into the name of your trust. All of those resources are there to support you financially during your life. And most people act as their own trustee, their own decision maker during their lifetime. It's really very nice. But if you become disabled during your lifetime and you can't make those decisions, then somebody else will step in and make those decisions for you according to the trust. And guess what? They only have access to the things that you titled in the name of your trust. And after you pass away, that person who is making all of the decisions for you during your lifetime, largely most of the time, not always, remains the same. So that person who's managing all those assets in your trust, your trustee, they are going to manage everything, the house and the accounts that are in the name of the trust. They're going to manage all of those same assets after you die because your trust document bridges lifetime and after death. It's a really great document. And so a few minutes ago, I gave you a list of everything your power of attorney for property does, your executor does, and your trustee does. And that's on the left side of this slide. And your trustee does all of those things. And other thing the trustee does is they can be very creative. Well, you can be very creative. When you draft the parameters that a trustee has, they can be super strict. You can be very strict when you're drafting your trust document. You get to say what happens with your pets. Like some people draw up trusts to take care of Fluffy. I had somebody who, when she passed away, her cats were to be fed very specific, very high-end food, and she put that. One of her cats got steak sirloin from a specific butcher until he passed away. And they put money aside for that. I've seen trusts where people say, my granddaughter can have all of my money after I die if she marries a Catholic. I have other trusts where people say that I actually am meeting with a beneficiary tomorrow and her attorney, that if she is 5 years sober, she can step in as her own trustee. So a trust is a very, very, very creative document. It's also a private document. So your will, you may already know that when you die, your will is filed with the in the county that you live in, and it's a public document. Now it's very hard to find, at least here in Illinois. It's very hard for laypersons to find a will that's been filed. Um, Attorneys know how to find it, and technically it's a public document, but a trust is not. Trust is a very private document. The only people that can see the trust are the people who are the trustee and the people who will benefit from the trust, possibly the people that you want to leave money to. A trust also is protected from court involvement. It controls the flow of money over time. And what that means is that, like I was saying earlier, your trust, any assets in the name of the trust are really there during your lifetime for your benefit. And then once you pass away, 30% goes to Fluffy's trust fund and 20% goes to a charity and the remaining amount goes to your neighbor. I don't know. But that's the nice thing about it is, you know, because the trust is a private document and nobody can access it, nobody knows what you do with your money with a private trust by design. And then the final piece that I'll add to this is the trust allows you to retitle your assets into the name of your trust. So I am not an attorney. I don't want to be an attorney. I know a certain amount about how the trust works because I serve as a trustee on a variety of trust types. So, but these decisions, I always tell potential clients of mine or people who are just wondering about this, your attorney will listen to your goals and your financial goals and your legal goals. They will make recommendations to you about, do you need a trust? Do you want a trust? And then they'll help you draft it. So you never have to do it alone. I wanted to show you an example. So a few minutes ago, when I said if your bank account is titled in your name alone, here's what your bank account might look like if it's titled in the name of your trust. So John Jones Trust. And then during your lifetime, if you're your own trustee, it will say John Jones Trust. John Jones is the trustee. That's what that will look like. There's a few different, there's a few different iterations, but this is a really great place for you to be able to decipher, like, I don't know if I have a trust. I don't know if my house is in the name of the trust. I think my husband did that. I think my wife was talking about it. Look at the title of things, and that's a great indicator for you. I want to bust some myths about decision making for these documents. So, and I also want to talk with you about, well, let me go back to this. So, just very briefly, I want to assure you that the powers of attorney for healthcare and for property, those do not take effect unless and until you are unable to make your own decisions. If you can make your own decisions, you ought to. Any good attorney will tell you that. Anybody who's supportive of your goals will tell you that. And whatever decisions you want for yourself, that's what you want to be sure that your agent under the power of attorney knows about. I'm going to give you some excellent tools for you to share those wishes with your decision makers. The trust document, that person has to, and these last three documents, the ones that all have to do with your finances and your stuff, those people who have a responsibility to you also have to keep account. They have to keep meticulous records of everything they did with your property and every nickel and every penny in your accounts. They can't just give your stuff away. That's why these documents are so important. They allow you to give voice. We're going to get to that too in a moment. There are three professionals that I strongly encourage you that if you do not have, consider finding one. And let me say about a certified elder law attorney, if you do not have an estate planning attorney and you're looking for a specialist for certified elder law attorneys, and by the way, folks, I know some of you on the call today are under 65, which is like the break-off point for, elder gerontology, elder law, those kinds of things. Don't worry about that. Elder law attorneys, their specialty is asset protection planning. Because Parkinson's is a progressive disease, the sooner you can give voice to your issues, to your concerns, to your goals, the goals of your family, the goals for your legacy, the goals for your assets, And sitting down with a certified elder law attorney whose specialty is drafting these specialized estate plans, the better off you are. And I have some resources for you on how to find one. If you say, pardon me, if you say, Colleen, I'm just going to go to my estate planning attorney, I don't have any problem with that. I would just ask you to ask them some pretty direct questions about, do they specialize in asset protection planning? And if they don't, ask them to help refer you to somebody that they trust who can do that. In my work, we always use a CPA, a certified public accountant. That person is going to know the tax laws in your specific state. This has less to do about saving money on your taxes and more to do as you grow in your care for Parkinson's. You may have lots of expenses that you can deduct. I would like you to have somebody in lockstep with you to advise you about those tax deductions. And then finally, a financial planner. If you have one, now is the time to disclose your diagnosis to that financial planner. Financial planners are not trained to ask you about your diagnoses. It sometimes takes you telling them, and I encourage that dialogue sooner rather than later. This gives you guys an opportunity to plan. It gives you a horizon that might be shortened as a result of the progressive nature of your disease. So now is the time to have these conversations. And if you don't have one of these professionals, I would encourage you to start looking for them. Okay? Find one. Very importantly, I want you to know that if you are like 99.99999% of the people out there, there is no silver bullet. There is no one bucket that is going to pay for your care. Rare is the client that can write a check from start to finish for their care. And even if they could, that financial advisor is telling them what to liquidate. You don't have to do it alone, and you shouldn't. Okay? There's good reason to liquidate some assets and not liquidate others. You should be talking with your financial planner and a CPA in concert with each other. And in my experience, those professionals love it when you involve them all at the same time for your benefit. Let them talk turkey. Let them talk over your head about all the IRA and the deduction and all those words and give you a recommendation. Bring them around you. Asset protection usually is a great opportunity. Most elder law attorneys can protect 50% or more of your assets if they have 5 years or more. It's always, if they don't have more than 5 years, don't sweat that. Just get a consult. Will you have to pay for the consult? Usually. Is it worth it? You betcha. Could be around $300 to $500 for one consult. But if you hire that elder law attorney, you're going to have that um, deposit or that consult applied to any future work. The other thing is a lot of times people have public benefits that they will leverage. What are public benefits? If you're a veteran, you might be entitled to a pension that will pay out to you or your wife for the rest of your life, or you or your spouse, I should say. Public benefits are also Medicaid, where you can become eligible in your state and protect your assets for the what we call the well spouse. Long-term care insurance, most people don't have it. But for people who do have a long-term care insurance policy, they ask me, when should I use it? When should I trigger it? That's one of those plans you can't take with you. The other thing is, and so the answer typically is trigger it now if you qualify. The other thing with insurance, long-term care insurance, if you don't have long-term care insurance, sometimes I'm finding that life insurance policies more and more these days are allowing you to add a rider to your current life insurance policy where it will act as a long-term care insurance policy. So just understand your options. Of course, your income, anything and this is why a financial advisor can be very helpful. If you have income and your only source of income is Social Security, I'm going to talk to you about how you can manage those resources and how you get that affordable help. And of course, your savings, whether that's investments, your bank account, you're selling your house, or you're pulling on the equity in your home. But know what those buckets are. Do not put your head in the sand on this. Learn which levers, which bucket you're going to empty out first. Okay. Why is estate planning important for Parkinson's? I've said it a number of times on this call. And that is, we know already that the Parkinson's Foundation and others are raising countless dollars to try to stem the tide of this disease, which is progressive and can be debilitating. So the sooner you give voice to what your priorities are, the better. In my experience, your long-term goals are unlikely to change. Do you want to age at home? Do you want to work with your disability at home? Not everybody does. That's okay. Do you want to move closer to family if the time comes? Do you want to move further away from family because they're driving you crazy if the time comes? Those are all things you can dialogue about today. You also provide guidance for your loved ones, that you've thought these things through. They're worried about you and they're afraid to have that conversation and make decisions for you that might step on your toes or insult you. Sometimes you're going to have a well-intended loved one who wants to take the reins. Disallow that if you'd like. Putting your wishes in documents is a great way to protect your interests and get everybody on the same page, whether they like it or not. Protecting your assets from the high cost of care, as I've mentioned, that is the specialty of of a certified elder law attorney. There are very few across our country. I'm going to show you how to get in touch with one. And lastly, perhaps most importantly, these decisions you need to make through financial planning, they force you in a really sometimes difficult way. They bring you face to face with the thing, by the way, most people are afraid to talk about, and that is your mortality. But your diagnosis it sort of takes that excuse away that you can't kick that can down the road anymore. If I'm honest, the sooner you start this conversation, the better, because of all the reasons I've just discussed with you. So I'll ask you, do you think it's important to have somebody care where your care is concerned? Do you think it's important to have somebody advocate for you? Do you think it's important to have medications, to weigh in about whether or not you're going to succumb to psychotropic medications? Do you think it's important to have somebody on your side that you pre-designate to manage your basic needs, your food, clothing, shelter, and medications? Do you think it's important to have care decisions made and give voice to those things? I'm going to move over to the financial side, but you can see the other examples here. Do you think it's important to give somebody the authority when you are unable to make those decisions? Do you think it's important to give people the authority to negotiate agreements on your behalf, to approve your expenses, to hire and fire people, to open your mail, to file your taxes, and to pay your bills? Because if you don't think any of those things are important, then do not move forward. But if you think any of these things are important and you want to give voice to that, then I urge you to start and take one step. So I promised you how to find an elder law attorney. There are two organizations I would encourage you to look at: the National Academy of Elder Law Attorneys and the National Elder Law Foundation. They are very related. The Elder Law Foundation is the accrediting body for certified elder law attorneys. Both of these organizations, a simple zip code search will get you to your closest elder law attorney in your state, in your region. Don't be worried if they're not right next door to you. in this day and age, but you do want somebody who practices in your state. Okay. Affordable resources. Sometimes people say, Colleen, that's great. Yes, I'd love to have an attorney do all those things. I'm here to tell you that every state in the nation has an American bar, has a bar association. Please look for one. Oftentimes, those are county specific or regional, and they do pro bono work oftentimes. Also, your legal aid offices are available to you through the Administration on Aging. Every county in our great nation has something called the Area Agency on Aging. That is a connection for the adult disabled and people over the age of 60 to access free and subsidized resources. And that includes legal services. So if you agree that you want the protection of an attorney to do these documents, to draft those documents, and that is best practice, please reach out to these different organizations if you do not have the resources to invest in your future. If you do have the resources to invest in it, I would ask you to go ahead and pay for that privately. These organizations are there for people who are truly destitute. Deciding what's important to you is very difficult. I'm going to wrap up here. I've just got this last slide. You know, there are different mechanisms for you to have these difficult conversations. And three of my very favorite resources are, one is called the game Hello. And Hello is a group of cards. It's just conversation cards that ask you and I to consider our disability. Since you have a progressive disease, this is going to bring you closer to some questions you may not even know to ask. I wouldn't say it's a fun game, but it is a game. It gives you an opportunity to really dig down a little deeper than you might think naturally. And then what matters to me? I love, 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 love this. This is called the Conversation Project. It is published, it's a free resource. It is published in many languages. It's been featured on ABC News. There's also one that's for dementia patients. The Conversation Project helps you identify what is important to you, and then you share that with your decision makers, or you do it before you sit down with your estate planning attorney to have these documents we talked about today drawn up. It's a really unintimidating conversational way to workshop you through some pretty personal questions, because it is different for everybody. And there's no wrong answer, which is, in my experience, the hardest questions to answer sometimes, when there is no wrong answer. The American Bar Association Commission on Law and Aging has published a phenomenal list of questions that you can answer and give to your decision maker. So all of these point to the same thing. I just wanted to give you a variety of options. And other than Hello, the game, these are all free. One other thing, I apologize, is what if you don't have anybody to call to step in? What if you are what we call a solo ager, or somebody who doesn't like or trust their family to step in? Then I would strongly encourage you to reach out to the Aging Life Care Association. These are advocates across the country. Again, a simple zip code search will get you in touch with advocates closest to you. And oftentimes these folks will step into those decision-making roles. Okay? I ask you one thing, one step. Take one step today after this conversation. Look into any one of those resources, and you're going to be ahead of most Americans, whether they have a Parkinson's diagnosis or not. I encourage you, please, to just take one small step, whether it's reaching out to a CELA, a certified elder law attorney in your region, or just asking for the slides from today's presentation and giving these another listen. That's my time for today, but I'm here for questions. At the end of the presentation, you're going to see what I call an authority chart. I did what I would thought might be helpful to you, gives you a little bit more information about the authority that you're granting people, the title that you have, your decision maker. My name is Colleen Ceh Becvar. I'm a gerontologist, and I thank you so much for your time today. Danielle and Brianna, I give it back to you.
Thank you so much, Colleen. You went through so many different terms and terminologies that I think it comes up so often from our programs here at the foundation. So I do think it was super beneficial that you were able to go through exactly what all of that means. So we have about 7 questions that came in during the talk. So we'll do our best to get to as many as we can. And for folks listening, continue to send your questions. Like I said, we'll try to use the time to really get through as many questions. But really to start off with, Colleen, like I said, you went through so many different terminologies. I had a clarification question from one of
Sure.
our attendees. They wanted to know what you mean by executor versus a trustee, and is that different from your power of attorney? So what's executor and trustee? What is the difference for those two?
So an executor only can serve in their role. They can only make decisions about your estate. That's after you pass away. A trustee can make decisions during your lifetime and after you die. So, and then the other part about the power of attorney, is that right?
Yeah, so if an attorney is different from executor and
Yeah,
trustee.
a power of attorney and an executor, those responsibilities are almost identical. The difference is power of attorney serves during your lifetime, and then their authority goes away. It terminates completely the moment you pass away, and your executor picks up that baton, and they have to do exactly the same thing that your power of attorney had to do during your lifetime. I hope that helps.
I think so. I appreciate it. So another question that came in is what kind of events or changes should prompt people to want to revisit updating a formal care plan that they've already put together?
I would say there, we refer to that as the 5 Ds. D as in David. So destination, if you move out of your house, move into a supportive living community, move into a nursing home, or your primary support. Let's say it's your spouse. So think about both of these things. So you or your primary caregiver. If you move, if there's been a divorce, if there's been and so that, I'm sorry, the move is destination. That's where that D comes in. Okay. Divorce, disability, yours or your primary caregiver. Decade, if there has, a decade has passed. Oh no, what's my 50? Decade, divorce, disability. I'll come up with it. I'll come up with the fifth D.
Yeah, no, thank you for that. It actually really ties into the next question. They were asking, how do I protect my assets while my husband with Parkinson's is in assistive living? So sounds like this is one of those instances that would count under the 5 Ds.
Yeah, absolutely. So your first goal is, so number one, you want to there are laws across the nation that protect spouses from becoming impoverished while caring for a disabled loved one, a spouse. Those are called spousal impoverishment laws. They're there to protect you from going broke while your husband is receiving the care that he absolutely needs and deserves, and that you cannot do, which is not your fault. Your number one step is to consult with a certified elder law attorney. If you take nothing else away from this conversation today, ask that question of that certified elder law attorney. You may not like the answers, but at least you make an informed decision.
And with a certified elder law attorney, there are a few folks registered for today who are a little bit younger
Mhm.
in Parkinson. So would they also want to reach out to a certified elder law attorney, or is it a different type of, is there an age limit, is what I'm trying to
There's
say.
there is no age limit, and I appreciate the question because the specialty of an elder law attorney, yes, while they are experts in all things aging when it comes to elder law, their primary specialty is asset protection planning. And that really is an umbrella that impacts not only older adults, but what we call in the biz, in the aging network, the adult disabled. And so that's anybody over the age of 18 who's looking at a high cost of care and a progressive disease. So, yes, you can definitely go to an elder law attorney. Thank you for the question.
Yeah, no, thank you for clarifying that. I think, like I said, a lot of different specialties were mentioned today, and really what I'm getting or what I'm understanding is your first next step is really to find a certified elder law attorney and to start talking about this.
Absolutely. Absolutely.
So let's say someone with Parkinson's is in the later stages of the disease and formal planning hasn't taken place yet. And that happens sometimes. This is future planning. And so sometimes life happens and we're not able to plan ahead. Well, actually, we kind of just answer this. What should family members prioritize to start the process? And it would be finding, you can go ahead.
Well, I find that most people, understandably, they worry so much, and I get it. They worry so much about the care piece. They're so, people envision themselves being disabled, or they envision their loved one living in a place that they don't ever want to live and not doing the things for themselves. And that's all care. So those questions that I gave you, like the three resources, the Hello Game, the American Bar Association, and the Conversation Project, those are all very focused on that care. So you've got to address the care plan from both perspectives. Yes, focus on the care plan. Yes, have those hard conversations. I'm not saying it's easy. I'm saying you can do it. That's not going to be your demise, having the conversation. And the other piece is you have to address the reality that Medicare does not pay for long-term care. It does not. So you have to have that financial conversation too. I thought of the other D. Okay. So it's the five D's are death. So if that person that you were going to turn to is going to be your agent, or decision maker if that person passes away. So it's death, divorce, destination if they move, disability, or decade. So if any of those things apply, you want to get a hold of your estate planning attorney. Just that's the trigger time.
So I think we have one last question here. It's when deciding who to make as your final decision maker, because it's a big decision. What safeguards can the person with Parkinson's do to help ensure that these individuals are acting in their best interest?
So that is a huge question, and one that speaks very much to the vulnerability once a person starts stepping in and taking over decisions. And what I will tell you is one of the great things about powers of attorney for property or healthcare is that they are what we call revocable. That all I have to do, if my power of attorney is not making decisions according to what I want, all I have to do is put it in writing or tear that up. That's it. That is my only requirement. It does not matter if you are having dementia episodes, that those documents are revocable. So if it gets to that point, the other thing is most times when you have those estate planning documents drafted, a good attorney is going to ask you to name successor decision makers. So don't put all of your eggs necessarily in one basket. Have other people who can act as a backup. And then when we're looking at the financial documents, all of those people, as I mentioned in the presentation, they absolutely must account for every decision that was made. They have to literally provide an accounting, a statement of every single thing they've done. They have to render that accounting to you, to your family, to your attorney and whoever else that you put in those documents. So there is oversight, and there are laws in every state that protect you, um, even if you've granted that authority to somebody else.
Thank you so much, Colleen. We are at time, so thank you for sharing your expertise with us today. Thank you everyone for joining us. As a reminder, today's program was recorded, and we will share the recording, the slides, a summary, and a lot of the different resources that Colleen had mentioned today, all in a follow-up email, so please just keep a lookout for that.
It's been such a pleasure. Thank you so much.
Thank you so much, Colleen. PD Health at Home is presented by the Light of Day Foundation, whose generosity has made this programming possible. Thank you so much again for joining us today. Don't hesitate to reach out to us. We have our helpline number over here, as well as an email address. Our website has a lot of information. So we do look forward to connecting with you again at a future program. Take care and be well. Thank you again for joining us today.